the purpose behind today's webinar is to discuss debts, waivers, and remissions. We're going to focus on the Defense Finance and Accounting Service, their process, although there are others who engage in what would ultimately be potential government debt issues. And obviously those processes are going to be slightly different. But those are things that generally we also have experience in. So, if you wind up having one of those issues and need to consult with counsel, you could always do so. But we're going to focus on the Defense Finance and Accounting Service process with a little bit of the service specifics as well, because remissions in particular do not get approved by the Defense Finance and Accounting Service, or what we call DFAS. The individual branches do. So that's me. Next slide, please. So here's a little outline of kind of where we intend to go today. So it's always important in these cases to find out sort of what the type and source of the debt is. Also important is, what is the status of the debtor? So are you somebody who's a federal employee currently, formerly? Are you a service member currently or formerly? Because these things are going to matter in terms of the process and in terms of whether or not each of these processes apply and how. Then we're going to talk about what you do when you have a debt, and are you doing a dispute or request for review? Are you seeking waiver? Or are you seeking a remission? Then with that, we discuss the process and the timelines associated with those things, if there are subsequent appeals. And then we'll briefly touch on if the actions have actually been adjudicated by the Department of Defense, if they then send them to the Treasury, the Department of Treasury. We call those Treasury actions in that process. Next slide, please. So in terms of the types and sources of debt, obviously there can be various potential sources of debt. And as I said, understanding why the debt is being sought to be collected is really the first step in the process. So the debt could be as a result of an overpayment or an erroneous payment or allowance. It could be as a result of alleged misconduct. It could be an attempt to recoup something like a bonus or a scholarship or some other form of educational debt. Understanding how the debt came to be about and why the debt is being collected, as well as getting an accounting of what the alleged debt is, will help you determine what is your best course of action moving forward. Next slide, please. So in terms of, who we tend to represent in these types of cases, generally probably our most common clients are people who maybe were part of the Reserve Officers Training Corps, or what they call ROTC. And when people are either unable to complete their commitment within the school, the college ranks, or have done something that prevents them from serving their service commitment as a result of that, can lead to debt issues with people who have been disenrolled from ROTC. Similar to ROTC, we have a lot of clients who are SMART scholarship recipients. SMART is a DoD program that provides educational assistance and stipends for individuals who are getting STEM, so science, technology, engineering, math degrees, and then will incur a civilian service obligations to the Department of Defense thereafter. And there have been many issues with that program and people being able to complete their obligations. So we have many clients who have debt issues as a result of their participation in the SMART program. We also have many clients who are either current or former service members who have debt issues resulting from alleged overpayments or erroneous payment issues. This sometimes comes up in issues of like when people were on TDY and they're submitting things like travel vouchers. There can be, you know, both intentional and unintentional issues that come up as a result of that that can create debt issues. We also frequently have both current and former service members who have debts related to alleged misconduct, you know, things as a result of like involuntary separation or failure to meet conditions of their active duty service obligations or bonuses. We also frequently represent federal employees with issues that are similar as to like overpayment, erroneous payment issues. Ultimately, we also do get a lot of clients who have VA overpayment issues, although we won't really talk about the VA process today because that's a bit of a different process and will be the subject matter. It can be a subject matter of its own webinar because they have really their kind of more own unique process of how to challenge debts or seek waivers. Next slide, please. In terms of determining, obviously, you know, this process and how to do things, as I said before, knowing what your status is or was at the time of the alleged debt is important because the processes are different from people who are, you know, having a in-service military debt versus a retiree versus a current or past federal employee versus somebody who maybe actually isn't in one of those positions, but may be treated similarly for purposes of how to challenge a debt. Next slide, please. So in terms of how to challenge a debt, there are different processes depending on what your complaint is. So the waiver or request for review is when you're challenging the validity of the debt. So that would be where you're disputing that the debt is owed from a legal perspective. Not that you think it's unfair, not that you think it wasn't something that you did to create it, but that legally that the government doesn't have the basis to collect it because it's not actually owed. And that can be because of a circumstance involving, you know, that there's an error in the amount. There might be some aspect of it that's owed, but you're disputing the actual amount of debt. Or it could be a question of whether or not you don't know what this debt is. This is the wrong person. This wasn't actually your debt. Or some other legal issue that prevents the collection of the debt. Waiver is an act by the government to intentionally relinquish its claim against an individual resulting from like erroneous payments of wages or allowances. It's not that the debt isn't owed, but the government is saying it's not in the interest of the government or that there's some issue in terms of equity, like fairness and good conscience, that the government is saying that they're not going to collect it because it, in essence, would be improper or unfair. Remission is the cancellation of a debt or a portion of a debt by the secretary of a military department. And you can probably get the idea by virtue of what it is that remission is only going to apply to service member debt. It's not going to apply to civilian federal employees or some of these people who are kind of in a quasi status. Next slide, please. So in terms of the dispute, if you're a military or former military member challenging a debt that is something that came from when you were in service, then you first are trying to identify where the debt originated. You'll get usually a notification letter that comes from DFAS, the Defense Finance and Accounting Service, and there should be a code that references what that is. And those codes, you can search them. Many times DFAS will push the idea of figuring out, you know, where the debt really originated from back to your finance, payroll, or just dispersing office. This is primarily for active duty service members. However, you do have the ability to request the information from DFAS or any other collecting agency to determine, what the debt originates from and the evidence they have to support it. So say, for example, they're alleging that you owed money because you didn't complete your ROTC obligation. Well, you may know that you didn't complete your ROTC obligation. However, you may not be entirely sure whether or not the number that they are assessing to your debt is accurate because you've never seen what the service branch paid the college. You've never seen, in essence, the receipts, and you are entitled to see those things when you're responding to this, because there can be errors in terms of whether or not they have legally supported what they're seeking to recoup from you. Now, in terms of if you're doing a dispute, what you're generally going to be focusing on is those types of issues that, well, now that I've seen the evidence, or maybe even when you haven't seen the evidence, that you're arguing that you don't owe this, or that there was some issue in terms of how the debt process arose that you have a dispute. So we'll use the ROTC example again. With ROTC issues, if you're being disenrolled, you're entitled in many different service branches to actually have like due process before you're disenrolled. If something happened in that process, you may have a legitimate basis to argue that they shouldn't be collecting from you because they didn't give you that proper process. So that would be something that you would ultimately be filing a dispute on in that instance, not necessarily a waiver. And when we are talking about when you're doing this, ideally you want to submit your dispute request within 30 days of the notification, because for a number of reasons, but primarily, number one, they usually will not collect in the interim. They will stay the collection of the debt while the adjudication process is going on. Now, that can be very useful because these processes can take a long time sometimes when you're dealing with the government, not always the fastest folks. When you owe them something, they want it yesterday. When they're processing whether they either owe you something or don't owe you something, they'll take their sweet time. So, in the interim, generally, you don't want to have to be paying on this debt while they adjudicate. So, it is a good idea to make those requests timely. Plus, they can technically deny the ability for you to have a review, an actual, like what we call a hearing, a paper review, if you don't submit timely. Now, if you first request the supporting evidence, you're generally going to extend your period so that your actual submitted dispute doesn't have to be submitted until after you receive the supporting documents, but it's always best to take those steps very quickly because you don't want to influence negatively the rights you may have because you didn't timely file. Now, when you're actually filing these, you're going to want to obviously have evidence, and it's not just good enough for you to explain your side of the story. You're going to want to develop information to attach with your submission so that you can ultimately support, what you're arguing about from, a much more persuasive front. You want to have, receipts, you want to have emails, you want to have, different documentation that might put into question, the legal sufficiency of what has happened. Next slide. So for purposes of the civilian employee, their process is a little bit more formulaic. Same types of timeliness issues. If ultimately you receive a notification of a debt within a timely manner, which is generally 30 days if you're CONUS, 45 days if you're OCONUS, you have to make a petition for a hearing. Now, hearing doesn't necessarily mean that you're going to go before some sort of adjudicative body. Most of these are what we call paper hearings. And, so you need to make that request very timely. Now, much like I was talking about before in the military process, if you do ask for the supporting evidence, they generally will kick out that deadline so that your actual submission isn't due until 30 to 45 days after the receipt of that material. But again, something that you generally want to be very careful of, because you don't want to then miss these deadlines such that they won't then consider your, matters for purposes of review. Now, with that, much like on the military side, you're going to be submitting written statements, other documentary evidence, any of the files that you may have received from the supporting where you might be pointing out errors. And then obviously you're trying to make a much larger argument about what the kind of lack of legal sufficiency is. What are the arguments? Much like I said before, if you do this timely, in many instances, they will stay the collection of the debt while the process is pending. However, if there isn't a stay, if they do collect in the interim, and sometimes this is done through like a salary offset so for people who are current federal employees, they will generally start deducting things from your check. If you are successful in this process, they return those funds. So it's not like, oh, because it took so long, I wind up having to owe a lot anyway. No, if you are successful, then you get, a refund from the funds that you ultimately paid. Next slide, please. So in terms of waiver and remission, we'll start off with waiver. So waiver, like I said before, this is not a situation where you don't owe the debt. It may be, though, that there's some sort of fairness issue at play where, it does not seem to be within good conscience or equity for the government to collect it. This is common in areas where you did nothing, but then got, maybe an overpayment or an erroneous payment, but you weren't aware of that for a long period of time, and then the government comes after you for sometimes tens of thousands of dollars when this was not something that you created. There can be an argument that it would be, fundamentally unfair for them to come back and collect that payment because you didn't do anything to create that. It can also be a situation of sort of a combination where you may have tried first a dispute about the validity of the debt, but ultimately it was unsuccessful. But because of some of those arguments, while it may not have been legally supported for the government to say that there wasn't a legal basis, it may ultimately reflect, though, that it wasn't very fair to collect it. So in the case of, let's use our ROTC example yet again for the service member, maybe there was some due process, but there were some issues in terms of the fairness of the deciding official. So maybe, like the professor of military science who made the recommendation, so maybe legally they had a basis to warrant the recoupment of that, but because of those different kind of fairness, equity issues, that ultimately they may agree to waive the debt because it's not really within the good conscience and equity of the government to now collect. Again, you're usually still going to be contacting the debt originator in order to gather, the supporting documents, because even though you might not be disputing the validity of the debt, you still will want to see what the evidence is, because that may support some arguments as to why it is unfair and inequitable to collect. There is a form for the Department of Defense called a DD Form 2789. But then it's usually not a great idea to only fill out that form. You're going to want to supply a supporting argument, different exhibits, different documents that help to support why the waiver is appropriate. Now, DFAS can't waive debts from certain departments that they're not going to be waiving Coast Guard debt, they're not going to be waiving VA debt, they're not going to be waiving debt from what they call DDoA, which is the Defense Education Activity, the Defense Intelligence Agency, Health and Human Services, the EPA. They have their own processes, and it's a different system by which you seek out. Coast Guard falls under DHS, the Department of Homeland Security. VA obviously has their own processes through the VA. Ultimately, DDoA, Defense Intelligence Agency, they have their own processes, even though they are under DoD. Health and Human Services and the EPA have their own processes. Next slide, please. So in terms of remission is only going to be for military or former military who have debt that incurred on active duty after October 7th, 2001. So there's a difference, obviously, between waiver and remission. Remission allows for not just issues of equity and, good conscience and fundamental fairness. It's also something that you can take into consideration people's financial and personal hardship, emotional aspects such as the member's value to the service, compassion, justice, good faith. Again, this is only applicable to debt that exists as a result of what we call in-service debt for active duty service members that occurred after October 7th, 2001. Each service branch, this is something that goes to the service branch. DFAS does not process the remission requests, and each service branch is different in terms of what their process is. Here are the citations. For some reason that says military, but that means Army. There are some processes, even though we talked about this being for active duty, there are some exceptions for certain types of National Guard members. And then obviously the Navy and Marine Corps fall under this separate statute. The Air Force falls under the same statute as the 10 U.S.C. 2774. But again, very similar in terms of the things you're going to be offering, but you also have the ability to argue about how collecting the debt would be, a personal financial hardship, not just addressing the idea of overall equities and fairness. Next slide. So in terms of appeals, once you submit these, ultimately, obviously the either service branch or DFAS could deny. And often as a result of that, you can seek a higher level review. That review could be again by DFAS. That's usually what we call a reconsideration. But it also in some cases can go to what they call DOHA, which is the Defense Office of Hearings and Appeals. Also, too, with certain types of debt, if you've exhausted those options, you may ultimately have the right to go to the Board for the Correction of Military Records. That is particularly true of things like remission. Remission, usually if the secretary concerned denies, you may have the ability to appeal that in essence to the Board for the Correction of Military Records. Next slide. As we talked about before, sometimes, particularly, when we're handling cases, clients come to us long after the debt notification has been sent and the debt is now in collection or wage garnishment proceedings or otherwise. In many instances, what happens if, and this can even happen when basically by you not even being aware. In fact, sometimes people's first knowledge of a debt issue is when they get notice from the Treasury or they see something on their credit report, particularly for older debt, where DFAS may be sending the notification to an old address. And DFAS is very bad about, they don't send things like certified. So they figure they've sent it out, they've sent a couple different notices, and then if they don't hear anything, they will ultimately send it to the Treasury to then do what the Treasury does, which unfortunately first is they usually tack on a penalty of usually 30% when it gets there. Now, sometimes in these cases, particularly with what I just described, when you were never on notice of the debt because it wasn't being sent to your current address, we've had success in going to the Treasury and going to DFAS and the service branch and asking them to send the debt back because you never really had the opportunity to challenge it properly because you were never put on proper notice. However, if you were put on proper notice, often there's not much we can do to prevent collection at that point. However, there are things that can be done to dispute things like wage garnishment, obviously argue for certain types of payment plans, etc. And that's something, obviously, if you needed assistance with, that's something that you would benefit from, having consultation with counsel. In fact, in any of these, often it is in your interest to reach out when you get a debt notification, particularly when you're talking about debts that are, more than $10,000, to discuss what the process is, what your best arguments are, even having legal representation to assist you through this process, because it can be very complicated, especially when you're alleging a actual dispute, because you often won't know what the proper legal arguments to make are, because a lot of this stuff can be very confusing. But even with waiver, we've helped many clients seek to waive debt and been very successful in waiver requests, because it isn't just an issue of whether or not the debt is owed, it's really the fairness of the scenario, whether or not there are kind of mitigating circumstances that warrant the government not collecting. Next slide. So as I was saying, that, in many instances, particularly when there's some complications, there's some issues that happen, like say for the example of the ROTC, or in a civilian debt issue where there's arguments as to the validity of that collection or the process and procedure, you often could benefit from, talking to legal counsel. And here's our information as to, how you would reach out so that you could get your own individualized consultation to talk about, how to address your potential debt issue.
Thank you everyone for joining today's webinar, and thank you, Heather, for presenting. Today's webinar was recorded and a copy will be sent to all attendees early or later this week. I hope everyone has a good rest of their night. Thank you.
Bye, everyone.